You done with your PCCs, Josh?
I'm done.
Oh, wow.
I'm done till 1:30. So you guys have me all day.
All right.
Bro, as soon as we get some people in.
Right. Courtroom 233, Judge Giles.
We got time to run up to chambers for a second.
Sure.
Okay, thank you.
You got Melvin Martin checked in.
Just use that. Oh, shoot. Courtroom 233. More.
Yep.
This is the D room.
Okay.
Yes, one moment.
Good morning. Can I speak to the court officer, please?
I should have said no. No.
Good morning, Officer Warren. Is that it? They said they were coming back, or they didn't say? So I might have to. Okay. All right.
Oh, Asia. What is this? Full love? It's full love.
Yeah, they said they got Owens. They didn't get Jefferson. I mean Peterson.
Full love is retained by Right Blake.
Did they see anybody else coming?
Right Blake. Oh, okay.
Right. They didn't know.
You need
How
a
you doing,
P number?
Mr. Paul?
Yeah, just get
Your client is out there.
37259.
Sorry, I'm late.
Okay.
Oh, this guy is still stuck in the breakout room.
Owens, I mean, Parker.
Oh, they got somebody else.
Oh, this is Mr. Gumpo. Is he ready?
Yeah, sorry, traffic was like crazy out there. I apologize. Can you speak my phone?
Yeah, traffic was crazy. I was late. I was mad. I don't like to be late.
You go on 75, that's good.
Yep,
It was an accident.
yeah. I should have got off, but you know how you get in traffic and you're like, oh, maybe it'll clear up. It never happened. I was like, forget it. Oh, I'll just have to be late. Mr. James? Robert James? Right. Mr. Robert James?
Yes, can you hear me? Hello? Yes, can you hear me now?
Now I can.
Yes. I'm wondering if I still should be on meeting right now waiting for the judge.
You're all set, Mr. James. Your new court date is June 12th at 11 a.m.
Okay.
It is in person, Mr. James. You have to physically be here. It's not on Zoom, okay?
Yes, ma'am. I will. I thank you so much again for your time.
All right, thank you.
Have a great day.
You too. Mhm. You can log off. You want me? Okay, I'm just gonna.
Yes, please do. Thank you.
All right,
All right.
that's okay. I understand. Oh, Mr. Sharp, good
Hello there, young
morning.
man.
Good morning. Good morning. Hey, Judge. Good morning. How you doing this morning?
How are
Now that I see you, I'm having a great morning, Judge. That's beautiful.
you? What's up? What can we do for you?
Judge, I have Mr. Taylor this morning for a PCC. I need to refer him to the Forensic Center.
I thought Jefferson was here.
She was, but he was off. He came back on.
Okay.
He just came back on.
I can do it.
You do it?
Sure.
Okay, now do you need the defendant here? He's in jail. No, okay,
You waive his presence with fine.
okay.
Oh, wait, we can't do it yet.
Oh, we need court report. Where'd she go? Did she say?
She said she's ready.
How many PCCs do you have left?
Just,
You all set on Parker
this one?
School?
and I got a comp hearing, which
I'm gonna talk
to do with that one. Courtroom 233, Judge Giles courtroom. Good, how are you? Jordan, is it Jordan?
Second chair.
Yeah. Oh, yeah, it is, yeah, it's Jordan. So what, somebody willing him out or something? Okay. All right, thank you, appreciate the call. All right. Pcel is here, he's being wheeled up, he's having a hard time walking. See him? And we ready on, that's our 10:15.
It's a whole, it's a.
Marker.
Can you give me the- Video conference.
What happened?
My video conference. Camera or something. I hear it shine. Somebody shine.
Oh. Which one should put, is that just one? Oh. Huh? Oh, okay. Every day?
Okay, so who's Mr. Gold on here?
He's on the 9:15 exam for Barker.
Apologize for my late, Your Honor, we'll put the traffic, I couldn't get. My client was.
Oh, this is a hold, so I was trying to get Mr. Sharp. We got wait on this.
We're just waiting on the court report, Mr. Sharp.
Much appreciate it.
Lawrence?
Yeah.
So they said they didn't bring him?
No, he's not here. He's back over at DOC from McCall.
Okay, so Judge, our 9:30, Sean Lawrence, oh, I guess we still got wait on the court for him.
Excuse me.
He's in Macomb County Jail, they didn't bring him.
So he's in a different location.
Oh, he's not in Macomb no
Yeah,
more?
that's why the written.
So where's he at now?
He's at Edward.
Prison.
So I don't know, they're gonna get them. Well, I know we have to do, well, read, oh, okay, all right. Oh, that's Judge Jefferson, she's probably back to do this too. Should use 2 weeks, right?
Yes, yeah, true.
She's seeing you. You probably see me, yeah. Yeah. Where's she from?
I know she has a judge.
These little people crack me up, putting this chair on high.
Oh, you. He didn't want to leave either.
Oh, I know.
He just did not want to leave.
He loves the criminal docket.
Yeah. Well, he might need some refreshers. I mean.
Thank you.
Oh, okay.
Sorry, y'all.
That's okay. You ready?
Court is now in session. All rise. Court is now in session with the Honorable Judge Kenneth J. King. I'm trying to remember the middle name. You may be seated.
Calling case number 2457385, the people of the state of Michigan versus Eric Taylor. The defendant is charged with count 1, assault with intent to murder. This matter is scheduled for a probable cause conference.
Good morning, Your Honor. Aisha Lewis for the people, PA 5520.
Good morning, Your Honor. Stephen Shark on behalf of Mr. Taylor, respectfully waiving his presence for the purpose of the PCC.
For the way the defendant's presence, what's your pleasure?
Your Honor, I believe Mr. Taylor needs to be referred to the forensic center. He has numerous psychological issues that need to be addressed.
Have you had an opportunity to converse with Mr. Taylor, and are you of the same opinion that an evaluation needs to be completed?
Yes, Your Honor, and I spoke with his family, and he's had numerous prior admissions into psychiatric centers before.
All right, that being the case, the court will refer the defendant to the forensic center for a competency evaluation. We'll set a review date for September 3rd, 2024 at 9:00 a.m. Bottle be continued.
Thank you so much, Judge. Great to see you.
Good to see you too. Have a good day.
You too. Thanks again. Bye-bye.
So Judge, the one I just need to do another writ on, do you want that on the record?
Take care.
Yeah.
Okay. Can you call Ms. Wallen? So I can do this.
Well read. Ms. Walker.
Attorney Wallen. I'm Sean Moore. Oh, all right.
That's the waiver.
Parties ready on Donovan Barker? Calling case number 2457193, the people of the state of Michigan versus Donovan Barker. The defendant is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, obstructing, count 3, weapons felony firearm. This matter is scheduled for exam.
Good morning, Your Honor. Agent Lewis for the people, P85520.
Your Honor, John Goldclaw, P30758, on behalf of Mr. Barker. Mr. Barker, please put your name on the record.
Donald General Barker.
Date and date and time set for preliminary examination. Are the people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
How many witnesses?
2.
Do you have any preliminary matters before you call your witness?
No, Your Honor.
No, Your Honor.
Okay, call your witness.
At this time, the people call Officer, I'm just gonna spell his name. It's Justin, Severinski. Server, Miss.
Oh, right here.
Sir, please give your name and spelling to the court reporter.
Okay, thank you.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat in the witness box.
Oh, I have this with me. The paper.
Yeah, just turn it over.
Yeah, when you're ready.
Can you please state your name for the record?
Justin Severinski,
And are you, where are you employed?
Detroit Police Department.
Okay, and then you can just sit back, because it'll pick up, just
Okay.
speak, clearly.
Here, let's do
And-
this. Put that on the microphone.
Yes, sir.
That'll do it.
All right, thank you. And, what do you do with the Detroit Police Department?
I work patrol,
Okay, how long have you worked patrol?
for about a year.
Okay, and on May 12, 2024, were you working, patrol?
Yes, ma'am.
Okay, and were you by yourself or with a partner?
I was with 2 partners,
Okay, what's your partner's name?
Officer Kennedy and Officer Simmons.
And on this particular day, were you working in full or modified uniform?
Full uniform.
Okay, and were you, working in a scout car on patrol or on foot patrol?
Scout car, man.
Was that scout car semi-marked or fully marked?
Semi-marked.
Okay, and when a police vehicle is semi-marked, what identifies that as being a police vehicle?
It says Detroit Police on it, red and blue lights.
And did your duties as a police officer take you to 10544 Finkel Street?
Yes, ma'am.
And is that in the city of Detroit, County of Wayne?
Yes, ma'am.
And on this day, were you patrolling?
Yes, ma'am.
And while you were patrolling, did you observe anything that caught your attention?
Yes, ma'am.
What did you observe?
I observed, a black man, which was later identified as Mr. Barker, Donald Barker. He's seen our scout car.
Okay, so you
Objection,
can,
false speculation.
Sustained.
yes, and, I need you to testify to what you observed, what you've seen, and, if you are able to articulate, your beliefs.
Okay.
Okay,
Yes, ma'am. I seen Mr. Barker walk across the street. Observed him while performing a retention check, which means, sorry.
I'll stop you there. Did you observe him?
Yes, ma'am.
Okay, and you said he did a retention check. Can you explain, what that is to the court, please?
Yes, ma'am. So when you perform a retention check, but basically it means, grab the, front waistband in your belt when you have a firearm to kind of fix it.
Okay, and is that what you observed, Mr. Barker do?
Yes, ma'am.
And do you see the person who you're referring to as Mr. Barker here in the courtroom today?
Yes, ma'am.
Could you please point to and identify article of clothing that they're wearing?
Stipulate for the purpose of examining all of your arguments.
So the court makes a finding that the witness has identified the defendant in this case, Donovan General Baker.
Thank you, Your Honor. And after making that observation, what, if anything, did you do?
I'm sorry, could you repeat that?
After making the observation of the retention check, what, if anything, did you do?
We began to follow Mr. Baker.
Okay, let me stop you there. Were you driving the vehicle?
No, I was not.
Okay, one of your partners. you're
Officer
driving?
Simmons was, yes.
Okay, and, so then he started to follow, is that correct?
Yes, ma'am.
All right, and what, if anything, happened next?
Mr. Baker began to start running on foot while still grabbing the firearm on his waist.
Objection, Your Honor. At this point in time, it's not indicated that he observed a firearm. It only indicated a detention check. There's been no observation.
What's your objection?
My objection is he said he was grabbing a firearm. I'm objecting to that. This claim that he observed Mr. excuse me, Mr. Barker grab a firearm.
Is that what you saw, sir?
Not the first time, no. It was,
Okay,
that's,
just tell us what you saw.
yes.
All right, can you please, you stated he began to run, and what was your further observations, if any?
Instead of the firearm, he was grabbing his waistband. That's
Okay.
what I meant to say.
And is that the same area where you saw him grabbing at, prior to running?
Yes, ma'am.
Okay, and what, if anything, did you do after making that observation?
Officer Simmons then turned into the parking lot of the address stated in the report. Mr. Barker was still running.
Okay, and, did you say anything as he was running?
No, we were still in the vehicle.
I'm sorry, is that?
We were still in the vehicle because he ran around the building.
Okay, and what, if anything, happened next?
Then, he soon got in front of the, building. There was a vehicle behind him. We began to bend down. Scout car then, came around the building. We began,
So let me stop you there. You stated he ran around the building. At this point, is he in the back of the building?
he did go around the building, yes. And then he went all the way back in front of the building.
Okay, all the way back to the front.
Yep,
And then you stated there was a vehicle there.
yep, there was a blue truck, I believe.
Okay, and what happened, what did you observe after that?
Then then me and my partners then, exited the vehicle. We, observed Mr. Barker, then start running, I believe it was southbound, across Finkel towards Pinehurst.
Okay, and when you made the observation of him running, across, to Pinehurst, where were you?
I was, me and my partner, Officer Kennedy were right behind him, and I believe Officer Kennedy was making commands to stop.
Okay, that'll be hearsay what, Officer Kennedy said, but, did you make any commands?
I did not know.
Okay, so, how long did this, last?
For the running part,
Yes,
I would say about 1 to 2 minutes.
Okay.
No, not 30 seconds.
okay, and did the, defendant stop at any point?
No.
Okay, and what, if anything, happened next?
I observed my partner, Officer Kennedy, pull out his taser, and he was then tased. It was effective. Mr. Barker fell to the ground. Me and Officer Simmons then detained Mr. Barker, and as we had Mr. Barker detained, we put him in handcuffs. Officer Simmons retrieved the gun from the front of his waistband.
Okay, and is that the same area where you saw him reaching, when you first, observed him?
Yes, ma'am.
Okay, and you observed this, recovery.
Yes, ma'am.
Do you recall the type of, firearm it was?
It was a handgun.
Okay, and what, if anything, happened next?
After that, we then placed Mr. Barker in the back of the scout car, waited for a supervisor to arrive on scene, and that was it on my part.
Okay, and did you ever tell him why you were arrested?
Yes, ma'am.
Okay, what did you tell him?
I'm sorry, can you repeat that?
What did you tell him?
For carrying a concealed weapon without a permit.
Okay. And did you ever, ascertain whether he had a, permit to carry or not?
I believe my partner did.
Okay, no further.
Cross examine.
Officer Severinsky.
Yes, sir.
Officer Severinsky, my name is John. I'm just going to ask you a question, okay?
Yes, sir.
If you do not understand those questions, then please let me know. If you don't hear me, please let me know as well.
Yes, sir.
Officer Severinsky, how long have you been a member of the Detroit Police Department?
I've been a member for about 1 year.
Thank you. And is that including your time at the academy?
That's another 5 months on the academy, with the
Okay.
academy.
Excuse me. And you are presently employed as a Detroit police officer. And which precinct do you work at?
Second precinct.
And are you on any type of special operations, or are you just routine patrol?
Routine patrol.
Okay. Now, on this day in question, you were on routine patrol with your partners, is that
Yes, sir.
correct?
Yes, sir.
And those partners were whom?
Officer Simmons and Officer Kennedy.
And who was the senior man on the car?
I believe it would be Officer Simmons. I don't know for sure.
Okay. And who was the operator of the motor?
Officer Simmons.
Officer Simmons, okay. Where were you located in the car?
I was in the back left seat, sir.
Back left seat, so you were back behind the driver, correct?
Yes, sir.
And where was, I'm assuming Officer Kennedy was in front passenger seat?
Yes, sir.
Okay, thank you. Now, you indicate you're on patrol and you observed a gentleman you later learned to be Mr. Barker walking across the street.
Yes,
Is that
sir.
correct?
Yes, sir.
Was he with anybody else?
I believe it was one or two other males, but I'm not 100%.
Okay, and you indicated that at some point in time, you observed him doing a quote retention check. Is that correct?
Yes, sir.
And you described that as an individual trying to adjust something in his waistband. Is
Yes,
that
sir.
correct?
Yes, sir.
Could have been a gun, could have been a holster, could have been a knife, could have been his wallet. Is that correct?
It could have
It
been.
could have been a lot of different things. Correct?
Yes, sir.
All right, thank you. You did not at that point in time observe any type of a firearm, did you?
Not at that time, no, sir.
In fact, would it be a fair statement, sir, that the first time that you observed a firearm was when it was taken off of his body, for lack of a better term, after he had been tased?
Yes, sir.
Now, I think you indicated that at no point in time, I'm sorry, after you observed this retention check, you then, did you say that the vehicle was turned around so they could follow Mr. Barker?
We were traveling westbound on Finkel, and after we observed Mr. Barker, my partner then conducted a left-hand turn into the parking lot.
Into the parking lot. And at that point in time, I believe you testified that Mr. Barker began to run. Is that right?
Yes, sir.
And did he run past the vehicle or just running ahead of the vehicle?
He ran behind us on Finkel, and then I believe he observed us while we were turning into the parking
I
lot.
didn't ask you what you believe, I just asked you what you observed. Okay.
Yes.
So he ran around the building, is
Yes,
that
sir.
correct?
Yes, sir.
And would it be a fair statement that after he ran around this building, you lost sight of him? Is that correct?
For about a second or so.
Second? Okay. Now, at what point in time did you exit the vehicle?
But what the time was,
Yes.
I don't know.
Did you chase him, you personally, run around and chase Mr. Barker around the building?
No, it was in the scout car.
Okay? Did any of the officers that you were with chase Mr. Barker around the building?
No, in the scout car.
Okay. I'm sorry, only in the scout car?
No, it was not only in the scout car, only around, when we were going around the building, it was in the scout car.
Okay. So there comes a point in time where you then exit the scout car along with both of your partners?
Yes, sir.
And at no time did you give any commands to Mr. Barker?
I did not know.
How long? Now, would it be a fair statement that while you were in the scout car, no one gave Mr. Barker any commands, didn't yell out to stop, didn't broadcast over your loudspeakers, anything like that? Is that correct?
No, we didn't do any of that.
No questions, Mr. Bishop. No further questions.
Just one question. When you observed the retention check, did you alert your partners to your observation?
Yes, sir. Yes, sir.
Okay. And after you alerted them to your observations, is that when the car Simmons turned the vehicle around?
Yes, sir.
Okay. No further questions.
Okay, so officer, we know that it's not possible for you to tell us what anybody else sees but you. But at the time that you made your observations of the defendant, that anytime the defendant appeared to look in your direction?
I don't recall.
You don't recall if he looked in your direction?
No, I know you've seen us driving on,
Well, you
Finkel
can't-
westbound.
Again, you can't tell us what someone else sees.
Yes.
But what makes you think that he was aware of your presence?
I believe when he saw us driving westbound on Finkel, that's when he began to perform the retention check and began to run to the liquor store.
Any questions based on my question?
Nothing but people.
Mr. Lopa, anything?
Nothing, Your Honor.
Thank you, sir. You may stay.
And the people will call Officer Dylan, sorry. We'll call Officer Dylan Kennedy.
Sir, please step forward, give your name and spelling to the court report.
First name Dylan, D-Y-L-A-N, last name Kennedy, K-E-N-N-E-D-Y.
Thank you, sir.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat in the witness box next to me.
Can you state your name and occupation, please?
Yes, my first name is Dylan, last name Kennedy, occupation's police officer, in the city of Detroit.
Okay, and were you working in that capacity on May 12th, 2024?
Yes, yes, ma'am, I believe it was May 11th.
Around what time was it?
I believe it's around like 12 or 11 o'clock at night.
Okay. And on this particular day, were you working with Officer Severinsky? And I'm sorry if I'm saying his name wrong.
Yes, ma'am.
Okay, and Officer Simmons?
Yes, ma'am.
And did your duties as the officer take you to the area of Finkel Street?
Yes, ma'am.
And, what were you doing in that area?
We were heading westbound on Finkel, just patrolling the area.
Okay, and while you were in that area, did you observe anything that caught your attention?
Yes, ma'am. I seen two males walking northbound towards Finkel on Pinehurst.
Okay, and can you tell me the lighting conditions in that area?
It was dark.
Okay, and you stated you saw two males. Do you see any of the males who you saw here in the courtroom today?
Yes, ma'am.
Could you please point to an identifier to a clothing?
Yes, ma'am. He's wearing a
Stipulate for the purpose of exam the defendant, Mr. Barker.
Court receives that stipulation.
All right, and what if anything occurred next?
I saw Mr. Barker perform what we call a retention check. He grabbed with his right hand, grabbed the front side waistband, pulled up towards his body, and then immediately started running across Finkel towards a liquor store.
Okay, and what if anything happened next?
Well, normally with a retention check, the person that does that would be armed, so.
Objection calls for speculation.
He said normally overruled, you may proceed.
Thank you.
And, I'm sorry, go ahead.
I was just gonna say, my partner then repositioned our vehicle, turning around while I kept eyes on Mr. Barker as he ran to the parking lot of the liquor store.
Okay, and did you give chase?
Yes, ma'am.
Okay, and, at any time when he was running around the liquor store, did you say anything to him?
Well, initially when he was running, we were still in our car, but when he took off on foot, when I ran active on foot, I did give verbal commands to stop running or you will be tased.
Okay, and did you immediately tell him that he would be tased?
Yes, ma'am.
Okay, so was your first command stop or you will be tased?
I believe it
He
was
did not
stop
say
running, you
stop.
will be tased.
He said stop running. Objection.
And could you repeat exactly what you said to him?
I believe it was stop running, you will be tased.
Okay, so stop running, or you will be tased. Okay, and did he stop at any time?
No, ma'am.
Okay, and what if anything happened there?
I then discharged my department issued taser, which took effect, stopping Mr. Barker at Pinehurst and Kinkle at the corner on the sidewalk.
Okay, and can you tell the court, and I'm just going back really quick, can you tell the court why you kept an eye on him?
Because when someone does a retention check, normally it's a subconscious thing where you pull up on your weapon to make sure that it's in your waistband area, so you pull up on it to keep it tight towards your body. It's like a natural thing that everyone pretty much does when they.
Your Honor, can we get back to
Okay.
questions and answers?
Yes, and what was your thought process behind that?
When I seen Mr. Barker do a retention check, my immediate concern was him carrying a concealed weapon.
Okay, and did you ever indicate to your partners your concern?
Yes, ma'am.
Okay. And I believe that is,
Cross examine.
Good morning, Mr.
Good morning, sir.
Officer Kennedy.
Yes, sir.
Thank you, Officer Kennedy. Officer Kennedy, I'm going to ask a couple questions. If you don't understand the questions, just say you don't understand. If you have an answer, then please answer correctly. Right? Understand?
Yes, sir.
Right? Or ask me to repeat my questions.
Okay.
Officer Kennedy, how long have you been a member of the Detroit Police Department?
A little over 4 years.
And where are you presently assigned?
I'm assigned to the 2nd Precinct Special Operations Unit.
And on the day in question, were you assigned to a special operations unit on this day in question, or were you only dealing with routine patrol?
I was assigned to a Special Operations Unit. Our scout car was 233.
Okay. And what is the purpose of a special operations unit?
We tackle more of the homicide suspects, carjacking suspects, CCW arrest, and narcotic arrest.
And on this day in question, you were on patrol, you weren't doing any type of special investigation, is that correct?
No, sir. We that's the our operation that day was to try to get either narcotics or weapons off the street.
In other words, you're out there looking for guns.
We were out there patrol. We were in the
You're
area.
out there looking for guns, right?
So we were
Among
out there
other
looking
things?
well, we were looking for either narcotics, guns.
Okay. And on the date in question, you were not the driver of the vehicle, is that correct?
No, sir. I was front seat passenger.
You were the front passenger. Officer Severinsky was the rear driver's side passenger, is that correct?
Yeah, I remember him in the rear. I don't know what side. Yes.
And you testified that while on patrol, you observed who you later learned to be the defendant in this particular matter, walking down the street, is that correct?
Yes, sir.
And he was with 2 or 3 other individuals?
He was with one other individual.
One other individual, okay. And did you ever learn the identity of that person?
No, sir.
Okay.
He was hostile and refused to answer any questions to us.
Oh, so you did,
Yeah, he stood on scene with us the whole
He
time.
stood on the
He wanted to
scene.
speak to our supervisor.
pardon?
Yeah.
I'm sorry,
I didn't hear your last question, sorry.
you said he stayed at the scene.
Yes, sir.
And at any point in time, since he was staying at the scene, did you at least get his name?
No, he didn't want to answer any questions.
Did he stay till the supervisor arrived?
Yes, sir.
Did the supervisor, without saying what said, did he make any contact with this individual?
I believe so. I was in the car running everything.
And as part of your report, did you learn, without saying what it said, who that individual was?
No, sir.
Now, it's your testimony that you observed this retention check. You did not observe anything of the nature of a firearm at that time, did you?
At that moment, no, sir.
Would it be a fair statement, sir, that at no time did you observe any firearm until after you tased him?
No, sir. When he had rounded the corner of the liquor store, he was trying to hide behind a vehicle. I could see him trying to remove what appeared to be a firearm from his pants.
And when did you see that, from the vehicle or from your?
That was from the vehicle as we were turning into the liquor store parking lot after we went around following him. So it's from our front windshield.
When did you exit the firearm, exit the vehicle?
At that moment, right when I seen him trying to remove a firearm.
Sir, at that moment, you followed him, you lost sight of him when you were around the building, is that correct?
No, we had eyes on him as we followed around the building.
Well, he turned, you were driving along the side of the building,
Yes,
correct?
yes, sir.
He turned around behind the building.
Yes, sir.
You lost sight of them at that point in time, didn't you not?
For a brief second, yes.
Okay, and then came all the way around the building, is that correct?
Yes, sir.
And while you were going behind the building and he was turning, you lost sight of him again, didn't you?
I believe we had eyes on him as he was.
My
running.
question was, sir,
Let him
did
answer
you?
the question.
I apologize, I apologize.
When we had went to the parking lot, I could see him round the building, yes.
And when you rounded the building and you were looking straight along the back of the building, after he rounded the building, you lost sight of him, isn't that correct?
Yes.
Thank you. Now, when was the next time you saw Mr. Barker?
When we pulled into the parking lot.
Please, when was the last time you saw Mr. Barker?
I last saw him was when he rounded the building to enter the front parking lot of the liquor store where he was hiding underneath the vehicle or next to the vehicle.
Okay, so he stopped running.
No, he continued to run after that. He had briefly stopped to what to me was he was trying to take the firearm out and hide it.
Objection, Your Honor. He hasn't seen a firearm at this point.
This is when I did see the firearm, sir.
Now, sir, you prepared a report this matter.
Yes, sir.
At any point in time in that report, have you had a chance to review that today?
Yes.
At any point in that time, in that report, did you indicate that you observed Mr. Barker attempting to remove a firearm?
I believe I did.
Now, take a look.
Yes, sir.
Take a look at the report, read it to yourself.
I didn't put that in my report.
You didn't put that in your report, did you? Kind of important, isn't it?
Yes, sir.
Didn't put that in your report, did you?
No, sir.
So in other words, you never saw a weapon until he was tased, is that correct?
No, sir.
I see, you just forgot to put this very important notification into this report, is that correct?
Yes, sir.
Now, you're in the vehicle, you're chasing him around the building in the car. There comes a point in time when you exit the car, is that correct?
Yes, sir.
Did both of your partners exit the car?
Yes, sir.
Where, excuse me, how far was Mr. Oh, and up to this time, no one has told him to stop, no one has told him anything, is that correct?
Yes, sir.
You then exit the vehicle. Where is Mr. I'm sorry, where is Mr. Barker? How far in front of you
I would
is
say,
Mr. Barker when you exit your vehicle?
I would say less than 15 feet.
15 feet. And did Officer Severinsky exit before you?
I believe we exited around the same time.
Okay, and then you gave chase on foot, is that correct?
Yes, sir.
And how far did you chase or try to catch up to Mr. Barker before you shot him with the taser?
I was not that far of a distance. He had struck a vehicle as he was running.
My question was, how far?
I'm not sure exactly how far feet wise.
At least, it was at least 15 to 20 feet. Would that be a fair statement?
I think it was less than that.
But you have no idea, correct?
Well, I can tell you it wasn't 15 to 20. I believe it was more like probably 5 feet, 10 feet.
So you were gaining on him, is that correct?
Yes, sir.
All right, and you then called out to stop, correct?
Yes, sir.
Or he'd be tased,
Yes, sir.
correct? And then how much warning did you give him before you tased him?
I gave him the 2 warnings to stop running, you're gonna get tased, and then I deployed and then discharged my taser.
And this was all, I'm sorry. Now, were any of your partners ahead of you in this chase?
I don't recall where they were at.
And you did not hear anything said by Officer Severinsky, is that correct?
In that moment, I was just focusing on Mr.
The question is,
Parker.
did you hear anything by Mr.
Objection, soliciting hearsay information.
You know,
I mean,
it
but you
calls,
know what?
it calls for a yes or no answer.
I was wrong.
No, I did not hear Officer Severinsky say anything.
Anything else at this time around?
Just quick redirect. You indicated that when the supervisor arrived, you was running information in your vehicle. Did you run the defendant's information?
I believe so, yes, ma'am.
And did he have a CPL?
No, ma'am.
Go for it.
Thank you, sir.
Thank you.
People have no further witnesses.
Any witnesses for the defendant? Your Honor.
Your Honor, at this time, the people will request that the case be found over. We do believe that there's a question of fact that a trier of fact. We heard from Officer Servernitsky, who indicated that he, upon being on routine patrol along with Officer Kennedy and Simmons, he observed the defendant walking across the street and doing a retention check, somewhat believing that the defendant may have saw him, understanding that that was stricken from the record as speculation. However, Officer Kennedy observed that same thing and both articulated on the record what they meant by a retention check. Both alerted their partner in the car, Officer Simmons, and alerted each other to what they had seen, upon which Officer Simmons turned the vehicle around and they began to follow the individual. Officer Servernitsky indicated that the defendant began to run and did another retention check. Officer Kennedy also indicated when the defendant ran, he briefly stopped at a vehicle, upon which he observed him trying to pull that firearm from his waistband, where Officer Severinsky saw it. And Officer Kennedy saw that retention check being done. Your Honor, the people will indicate that the Officer Kennedy did give at least 2 commands to the defendant to stop, and when she didn't stop, both of the officers indicated that they were wearing full uniform on that day. And a reasonable person the people believe that a reasonable person would believe that an officer running after him, but upon which telling him to stop or he will be tased, is acting, performing his duty under the law. So, Your Honor, with that being said, the people do believe that this is a question of fact for the trier of fact, being that there was a firearm also recovered from that same area where both officers saw that retention check being done and the defendant not having a CPL.
Yes, Your Honor. Your Honor, this is an examination. However, Your Honor, I would like to point out that the testimony of Officer Severinsky was that at no time did he ever observe any type of firearm until Mr. Barker had been tased and was on the ground.
That's the first officer, right?
That's the correct,
That's not the second officer
I
testifying.
know that's not what the second officer said, that's why I want to address this issue. Officer Severinsky was the one who alerted his partners to this retention check. Officer Severinsky also stated there were 2 retention checks and that at no time did he observe a weapon. Third, Officer Kennedy was in the front passenger seat. By his own admission, he lost contact, at least observations, for a brief period of time while they were chasing this gentleman around the building. Officer Kennedy indicated that he observed what he determined as similar to a retention check. And at this point, while I'm assuming behind the individual, claims he sees him reach into his front waistband. He's back there. Mr. Barker is running that way, stops by a car, and now he claims he sees a weapon. And that's his testimony, Your Honor. It's also interesting to note, Your Honor, when I asked him, did he make any mention of this observations? And he indicated no. But first he said, oh yeah, I said it. And when given the opportunity to review his police report, he said, no, I guess I didn't. He testified this was very important, and I would suggest to this court that the court can, is not only is there a probable cause, a preliminary examination, was the crime committed, but you can go to the credibility of the witnesses at this point in time. It's also interesting to note that at no time did anyone call out or yell out of a car window to stop. Nothing was done by any of those officers. Finally, and as you've heard from Officer Severinsky, he never told anybody to stop. He never said he was going to use his taser. And the first time he sees the weapon is when it's taken off of Mr. Barker after he's been tased. Not by the car where this retention check allegedly showed that. I would suggest, Your Honor, that the people have failed with respect to the identification or the proper of the commands. No command was ever given, and no command was ever given to him until.
So what was that testimony about stop where I'm gonna tase you?
Until, that's what I was gonna say, until they exited the car and he was not given an opportunity to stop. It was tased immediately. I would suggest to the court that at least with respect to the R&O, that the people have failed to provide sufficient evidence to find him.
I respectfully disagree. I didn't find anything inherently incredible about either officer's testimony. In fact, the fact that their testimony does not mirror each other gives credibility to their testimony. Because if they wanted to get together and make up this lie on the defendant, then they could very well have made it a juicier story than what it is. I think both officers testified honestly as to what their recollection was. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint form. The court finds those charges were committed in the city of Detroit, and the court finds probable cause to believe this defendant committed. The defendant will be bound over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 18th, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor.
Ms. Walker. Ms. Walker.
Parties ready on Sean Lawrence?
Yes.
Calling case number 245761, the people of the state of Michigan versus Sean Lawrence. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, assault or assault and battery, habitual offender, second notice. This matter is scheduled for exam.
Good morning, Your Honor. Asia Lewis for the people, P85520.
And good morning, Your Honor, Veronica Walrat with the P85665 on behalf of Mr. Sean Lawrence. Your Honor, a writ was submitted with the Macomb County Jail, but since that writ was submitted at the first PCC, his location has changed. I've been able to confirm through one of the deputies using Vine Lincoln and also through Owens and his mother this morning that he is now at the Charles Egler Reception Center. And so we will need another writ and another date, obviously.
Okay. The court finds good cause to adjourn this matter. I will adjourn it to, it's gonna take about 2 weeks to get him here. I'll adjourn it to June 18th. At what time?
Anytime works for the defense attorney.
Judy, what time are we doing it? June 18th?
Oh, 9:30.
It's June 18th at 9:30. Bond will be continued.
Thank you, Your Honor.
You're good. What's your name? Mark. Mark, you just call.
Mr. Bradford.
Is Mr. Bradford ready?
He stepped away, so, yeah. Gonna get Mr. Owens.
Yeah.
Ready?
Mr. Bradford, I'm ready. Okay, step over.
I just need 1 minute.
Have a seat. That's what it is.
There's no.
You get called white.
There's no thoughts.
No, you get called white.
You ready on Melvin Martin?
1 second.
June 18th at 9:30. Wait. Yeah, she said give her 1 minute. ready now. Calling case number 24578084, the people of the state of Michigan versus Melvin Martin. The defendant is charged with count 1, controlled substance, possession cocaine, heroin, or another narcotic less than 25 grams. This matter is scheduled for exam.
Good morning, Your Honor. I'm sorry.
Go ahead.
Oh, Agent Lewis for the people, P 85520.
Morning, Judge. Ronald, with the USP 83424, appearing on behalf of Mr. Martin, who's present in court.
Tell us your name, sir.
Melvin Martin.
There's date, time set for preliminary examination on each witness.
Yes, Your Honor, the people are ready to proceed.
How many witnesses?
Just one.
Have any preliminary matters before you call witnesses?
Yes, just one preliminary matter. The people move to admit the people's proposed exhibit 1, the preliminary drug analysis under MCL 766111B, stating that the suspected narcotics recovered tested positive for 3.4 grams of cocaine.
Any objection?
There's no objection for exam purposes, but we also have one preliminary matter of our own.
All right, admit it. What's your preliminary matter?
There was an issue of digital discovery. I know it's Judge Giles' practice where a court signs a discovery order. The defense does not receive the request of discovery. He entertains a motion to dismiss, so I'm making that motion at this time. There is a signed discovery order. We do not have a digital discovery in this case.
And did you bring that to the people's attention?
We had a hearing on it yesterday. They were present, and I have a signed copy of the order. And I believe there is one in the court file as well, Judge Wagner, I believe.
And Your Honor, the people was under the belief that their discovery order was still in question, so I did not know that Judge Wagner signed the order. He stated that we would deal with whatever was going on today, and it was the indication regarding the lien was the issue.
And so, Judge, I'm not springing this on the prosecution. I raised this immediately after the probable cause conference. I raised it at the probable cause conference. I sent an email about it on the 24th, and I signed it the day before. So there was ample opportunity. This is not an ambush by any means. And the court speaks to its written orders.
So
may I have a second?
you don't have digital discovery?
I do not. I do not have the dash cam. I do not have the body cam.
And you brought that to the people's attention?
I did. Multiple times.
I have that he was sent digital discovery on the 1st, so.
I sent the follow-up email about that. It's for the wrong case. And I do try my best to put people on notice and far out advance as possible to avoid situations like this.
I can just have one moment, just.
What's this talk about the lien?
Oh,
They can't give that to you.
I understand that, Judge, but the issue was that I submitted a scale approved short discovery order. Line 4 says the arrest and conviction record of the defendant. I was not asking for the lien information itself, but just Mr. Martin's previous criminal history. It's routinely disclosed when people are charged with typical offender notices, and there's a statute on point that says prosecutors can disclose it.
I'm not so concerned about that as I am with the digital discovery that you don't have.
Your Honor, I'm having trouble trying to download it, exactly what it is, so that I can see that it's the wrong. I do have that, it is that correct officer, and I have the other officer that's being here.
So when was that given?
On the 1st.
On the 1st, but it was brought to your attention yesterday that you didn't have it.
Well, no, that was not brought to my attention yesterday. The issue in regards to the discovery order, he never mentioned that anything was wrong. He stated, we got into it about the lien information. And then the judge stated that he would hear this today, was my understanding.
I have an email right in front of me. I sent it June 3rd at 11:07. Sorry, I'm looking at an email that I sent yesterday at 11:07 a.m. Asia Lewis, Gunnar Mathley, or CC'd on it, in which I specifically point out it's the wrong video. And then I subsequently signed on to address discovery order issue.
Okay, well, I did not see that email as I stated. I thought that we were handling the discovery issue today. I did not
So
see
you
the
sent
email.
the email before you appeared before the judge?
I did, Judge.
And you didn't bring it up before the judge?
I believe I did.
What you mentioned in your email?
Yeah, I said I do not have the relevant digital discovery for this case.
Oh, you did.
I did. I mean, am
I don't recall that being mentioned.
I'm not trying to blindside anybody.
No, I understand. However, I don't recall that being mentioned. I do understand if council doesn't have the correct one. I just asked to be able to review this. I do have one that's coming up right now. And I just asked for a moment to review to make sure that's the wrong. Okay.
Which my position would be.
What did you say? What you said, something I need to get that.
Yeah, I said my position would be, and then I said I would.
Okay, thank you.
If I could just get 1 second, the OIC can tell me if this is the number on the right page, and that'll be easier.
Unfortunately, Judge, I think we could, an appropriate remedy would be to dismiss and they can refile and this could be heard in front of Judge Giles. The actual judge on this docket.
I'm the judge on this docket.
That's fine, Judge.
Are we still on record, Judge?
Yes.
So the video that I have pulled up here indicates that it is Officer Smith video, which is one of the officers that responded. The code on it is 2021, January 25th. It starts at 22:32, which is 10:32. The report here that we have is January 25th, 2021, starting at 22:33. So it is the indication that this is the correct video, and this appears to be the defendant here on this video.
Just the issue is, I've never seen that video. The video they sent me was surveillance footage from Circus Park.
This is
Unrelated people, and I downloaded it. I'm now seeing this video for the first time at the 11th hour when I've made 4 attempts to receive this video. Mr. Martin has rights. He has a right to effective assistance of counsel. Prosecutors should not be able to disclose evidence that they've had this entire time immediately before the preliminary examination and tie my hands together.
Your Honor, I would indicate that
When did you send that to me?
this is the part of the package that was sent, the zip file that was sent on the 1st.
It wasn't. I can show you the file there.
I would have to have you speak up, sir. I didn't hear you.
That video was not in the video file that I downloaded. The file that I downloaded contained 1 Genentech video, and it was surveillance footage from Grand Circus Park, which has nothing to do with this case. I, as an officer of the court, have never seen that video, and I've been diligent about trying to get the discovery.
It was sent to the general NDS email, which is what the conditions that we have between our office and your office, that it was sent to their general email, the neighborhood defender's office.
Show her what was received and the date it was received. That she sent it to you on the 1st.
And I would indicate that's AP and Muhammad who sent it.
So I'm not sure about your internal workings at NDS. Is it possible that they could have given you the wrong one? Since it's not directly sent to you.
Sure, I guess it's possible. I can't speak with certainty, but I'm not in a position to dispute that.
So why, if that is possible, why should I penalize the people if they've done what they're supposed to do and getting you the discovery well before the preliminary examination, but because of your own internal workings, an error was made and they gave you the wrong video? So how do I penalize the people for that?
Well, it's not entirely without fault. The video file that they're saying that they sent was sent a day before when I initially requested it on the.
She said that was on the 1st.
June 1st.
There's the report.
Let me use, I have used this clicker, so.
Well, I guess my response to that would be, if we don't know where the fault lies, Mr. Martin shouldn't be.
I'm gonna dismiss the case. If it's, the blame lies with NDS getting you the wrong information.
Ready to proceed either way, just make it.
How long is the video?
It's an hour.
You do have it now, Mr. O?
I don't.
I'm just gonna resend it and send it directly to him, to his email.
So in all fairness to you, Mr. O, I want you to have an opportunity to review the videos. Are you able to do this tomorrow?
Just my comment. I'm available tomorrow.
All right, let's put it over till tomorrow. Okay, what's a good time for us to do this?
Exams at 15 minutes. After 11:15.
How's 11:30?
11:30 works.
All right. Court finds good cause to adjourn the matter to June 5th at 11:30. Bond will be continued.
Judge.
Make sure he gets the video.
Yes, I just resent it and he can stand in front of her.
Acknowledge receipt of it, Mr. O.
I just opened. So we know.
Thank you.
All right. Yeah, I get you.
Yeah, are we all set now?
Yes, sir, thank you.
Okay.
Party's ready on Joe Purcell.
That was at 11:30, right?
Yes.
Can you walk it on? Yeah, we can walk. Which guy?
Calling, calling case number 2457-238.
Is it?
He's gonna stay right
He's
there.
gonna stand right there.
Okay. Calling case number 2457-238, the people of the state of Michigan versus Joe Purcell. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, weapons, felony, firearm. This matter is scheduled for exam.
Good morning, Your Honor. Angel Lewis for the people, P85520.
Good morning, Judge, Junior staff, Cody Bradford, Neighborhood Defender Service, P85944. I have the pleasure of representing Mr. Purcell, who stands to my right. Mr. Purcell, can you state your name, please?
My name is Joe Pcel III.
There's a date and time set for preliminary examination. Are the people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
How many witnesses?
It would have just been the one, but I believe that council has elected to waive the rights to the preliminary exam, and the people have no objection.
That is correct, Judge. I spoke with Mr. Purcell about his right to preliminary exam, as well as the standard of probable cause and what testimony or evidence needs to be given today to satisfy that. At this time, it's my understanding Mr. Purcell would like to waive his preliminary exam.
Mr. Purcell, are you able to raise your right hand?
Yes, sir.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Sir, you understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with plaintiff warrant. You understand that?
I mean, you said that, please slow that down. This is my first court case ever. I don't really understand these court terms, but I'm trying to really get everything broken down to me in layman's terms.
Let's try it again. You understand you have a right to have a preliminary examination. By waiving your right to a preliminary examination, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with complaint. Do you understand that?
Yes, sir.
Do you understand the nature and the purpose of a preliminary examination? You know, that's okay. I'll explain it to you.
Yeah, he said it was, my attorney told me it was about a probable cause or something. I'm
Okay, so
lost,
listen
man.
to me. If you were to have one, the prosecution would have to establish that the crimes you're charged with were committed in the city of Detroit and that there's probable cause, not proof beyond a reasonable doubt, but probable cause to believe you committed them. They would do so by calling witnesses to come forth and testify as to what allegedly took place. At the end of the day, if I'm satisfied that the people have met their burden of probable cause, then I would bind the matter over to Wayne County Third Circuit Court, where you'll be arraigned on the information, which means you're told what you're formally being charged with. At that point, you'll either schedule for a trial or entertain any plea negotiations that may be available to you at that time. By waiving your preliminary examination, we skip that part about witnesses coming forth and testifying, and you're acknowledging that there's at least probable cause for you to be charged. And so I will bind it over to Wayne County Third Circuit Court, where again, you'll be told what you're formally being charged with, and you can either schedule for trial or entertain any plea negotiations that are available to you. You understand that?
Okay, now with that being said, sorry about this mix up stuff because I don't know about this stuff. So what you're saying is that witnesses can come to court today?
Yes.
People who've witnessed it?
Yes.
And,
Whatever the prosecution is deemed necessary to prove that there's probable cause for you to be charged.
oh no, see, I'm thinking for like the people who seen it, I only knew the only witness was the young lady or the person who lied on me, so I don't
Typically,
know.
the defense does not call witnesses at the preliminary examination. That doesn't mean that you can't, but typically they don't. It's the prosecution's burden to prove that there's probable cause to believe these crimes were committed in Detroit, and that there's probable cause to believe you committed it. They would do so by calling witnesses to come forth and testify. It's not proof beyond a reasonable doubt. It's probable cause, which means more likely than not for you to be charged. Do you understand?
Yes, sir.
Is it still your wish to waive your preliminary examination?
That's what he's asking. Do you want to waive?
Okay, see, I'm going off of my assumptions. I'm thinking just me coming here to court today, everything was gonna be over with, and like, I just wanna go home to my family still, my daughters. I don't know what's going on, like truthfully. So once again, I truthfully apologize to everybody in here because I don't know, but I gotta ask questions because my life is trying to be taken away from my daughter. So that's what I was trying to ask you guys as far as the witnesses. So I don't mind waiving the preliminary thing.
Okay, is anyone forcing you to waive your right to a preliminary examination?
Yay and nay. I was told that you were gonna lock me up or take my bond, that I wasn't gonna. Okay, well, it was a possibility of you to just lock me up today, just because someone said something, and that's I've already been through enough, man. So that's where, sorry, Judge, Mr. King, Mr. King. My apologies, it's just been a lot on me already, and by this being my first court date, I don't know anything. I have faith in the system. It seems like I'm guilty until I prove my innocence. So that's where I don't want to waive it, but I don't want you to lock me up and I'm unable to go to work as well. So that's what I'm thinking, I don't know about this stuff. I don't know. That's what's making me speak out today because I don't have money for a lawyer. I'm speaking to you guys directly to the courts. I'm just trying to figure out how this stuff goes. So that was really it. So I don't mind waiving it, but.
Sir, I don't want you to be under the impression that I'm going to lock you up if you don't waive your preliminary examination. That is not going to happen. In fact, the chances of me locking you up are almost none unless you do something disruptive in the court and I hold you in contempt of court. The purpose of bond is to make sure that you come to court, that you don't pose a danger to the community. You're here now, you walked in on your own.
Yes, sir.
You rolled in here on your own and you're standing before the court now.
Yes, sir.
So I don't have any reason to believe that you are at flight risk.
Okay.
I don't know anything about this case and I won't know anything about the case until I hear from witnesses, unless you waive the preliminary examination. Now, if for whatever reason, your charges are serious, but they're not the most serious charges that I get, okay? So unless there's something learned that shows that you are a danger to the community, I'm not going to revoke your bond. You haven't done anything, so far as I know, in the court to do that.
Okay, now, because as I was speaking to my attorney, I was only, I don't know anyone here besides my family, so I just have to ask questions. Because I'm really, I've never been in court, court, only a ticket, a traffic ticket, so this is really scary to me, but, what was I gonna ask? Sorry about this stuff.
Sir, the only thing I want to know is if you want to, I don't know if your attorney advised you to waive your preliminary examination, but if you want to take your attorney's advice or you want to hold the preliminary examination where witnesses will come forth and we go through the whole process of the bind.
No, okay. Is it possible that I can have more charges brought on me?
That is a possibility.
Okay, see, no, and that's. No, I need to just ask questions because I don't know.
That's a possibility that if the facts bear out based on what the witnesses say, that the charges could change, they can become more serious. If the facts bear out that this is an assault with intent to murder, for instance, as opposed to an assault or dangerous, assault with a dangerous weapon, or assault with intent to do great bodily harm. There's also a possibility that charges could be reduced or dismissed. I don't know, because I don't know anything about this case yet.
Yeah, that's, okay, see, I was more, I don't have the 911 calls, you guys didn't get that, I guess, or the stuff for my behalf, so that's why I was waiving it. I didn't want anyone to make any more lies on me any heavier than what they already are.
Sir, I just need one question.
Yes, sir, I'll wait,
Because I have a
yes.
lot of time.
Yes, I so apologize for this inconvenience. Yes, sir, I'll waive it.
So it brings me back to my original question. Is anyone forcing you to waive your preliminary examination?
No.
Has anyone promised you anything?
No.
Are you waiving it freely and voluntarily?
Yes, sir, no, I'm waiving.
Are there any objections from the people?
No objection, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily given. The court will therefore bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 18th, 2024 at 9:00 a.m. Bond will continue.
Thank you, Judge.
Thank you.
Now, 1 second, Judge.
Taking all my seconds up. You're taking all my seconds up.
I'm sorry.
He's about to pass out. So.
Oh, yeah.
Thank you.
Right, this show?
One moment, my apologies.
That's on Owens, right? Let me get fingerprint, Mr. Owens.
What was his name? I'm not able to.
Yeah.
And,
That's right.
he's an attorney.
Ty, this is for Mr. Owens.
Oh, 40 years out. And do you read it or bring it back?
Yeah, they'll bring it back to me. It's for the number. Oh, is it, oh, where's she go? Is it Owens or home?
I just want to make sure.
I don't ever read freely. I know, like, I'm so weird.
Huh? Yeah, Owens is next. Yeah. Is Willie Dell here more?
Willie Dell is here, and Mr. Gable, his attorney, is here.
Are
And
they ready?
they wish to hold. And Terry Peterson said yes.
Oh, Sarah Peterson isn't in.
No, he got the other.
Oh, okay. Are you holding this?
I will let you know in 1 second.
Oh. Yeah.
What is?
It's a different, yeah, here.
He's on this way.
I think so.
He says that.
Oh, I have the Israel and not the
Okay.
Well, the attorneys keep telling me they didn't try. They didn't try.
You got lucky. Huh? Yeah. I'm surprised either too. Yeah, damn. Are you ready on jail, Adrian?
I'm about to go check. I'm ready on Owens. I'm ready on Peterson. I know that's skipped. I'm checking that.
I know. Mm-mm. The hangnails. So we're gonna do the other one.
Yes, ready on bill.
It's ready on there. So we're gonna do the other.
Oh, I got one thing, sorry. Tell her I got one.
Where's Moore at? Moore, tell Dale to come in. Dale and his attorney, what is his name?
Cardinal Jail.
I don't have a whole jail here. How many witnesses on Dale?
It should just be the one.
Okay. Parties ready on Willie Dale?
Sit there or
Oh, I.
Y'all heard that?
Yes. You heard it too. Calling case number 2457158, the people of the state of Michigan versus Willie Dale. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. Habitual offender for notice. This matter is scheduled for exam.
Appearances for the record, please.
Asia Lewis for the people, P85520.
Ronald, P6397 on the behalf of Christopher Dale. Standing here. State your name, Mr. Dale.
Willie Dale.
Oh, Willie.
There's a date time set for preliminary examination. Are people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
How many witnesses?
Just, should just be the one, Your Honor.
Any preliminary matters?
No preliminary matters.
All right. No further witnesses.
At this time, the people call Officer Tillman, Antonio Tillman.
Sir, please give your name and spelling to the court reporter.
Antonio.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Please have a seat in the witness box next to me. You're ready.
Can you please state your name and occupation for the record?
Sir Antonio Tillman, with the Detroit Police Department.
Speaking to the microphone, of course, Mr. Tillman.
You can move it.
Officer Antonio Tillman with the Detroit Police Department.
How long have you been an officer?
I would say 7, 8 months.
And were you working in the capacity as a police officer on May 8th, 2024?
Yes,
And were you working by yourself or with a partner?
with a partner.
And what's your partner name?
Officer J. Cron.
And, on this date, were you working in full or modified uniform?
Full.
And were you on foot patrol or in a scout car?
Scout car.
Okay. And was that car semi-marked or fully marked?
Fully marked.
And did your duties as a police officer take you to 2675 Glendale Street?
Yes, ma'am.
And is that in the city of Detroit, county of Wayne?
Yes.
And why were you at that address?
For domestic violence.
Was that a police run?
Yes, ma'am.
Okay. And when you arrived, what did you observe, if anything?
Upon arrival,
Yes.
we observed the victim walking from the side of the house. We questioned him, asked him the situation. He stated,
Okay, so without telling us what the victim stated, did the victim tell you something?
yes, ma'am.
Okay, do you recall what this person's name was?
No.
Okay, but you did speak with him?
Yes.
Okay, and after receiving that information, what, if anything, happened next?
I observed Mr. Willie Dale open the front door with a knife in his hand.
Okay, and the person you're referring to as Mr. Willie Dale, do you see him in the courtroom here today?
Yes, ma'am.
Could you please point to an identified article of clothing he's wearing?
A red, black, and white flannel shirt.
Your Honor, may the record reflect that the witness has identified the defendant.
So noted.
Okay, and you stated he had a knife in his hand. Could you describe this knife?
Objection. What's the relevance? The knife in his hand. I don't see any purpose to it.
Overruled. May proceed.
So could you describe this knife that was in his hand?
It was a long kitchen knife.
Okay, and after making that observation, what, if anything, did you do next?
Me and a few of the officers advised him to drop the knife.
And did he drop the knife?
Yes, ma'am.
Okay, and what happened next?
I asked him if he can step outside, and he stated no.
Okay, and what happened after he stated no, if anything?
I approached him and grabbed him from outside the door, pulled him out, and placed him in handcuffs.
Okay, now why did you approach him?
Because it didn't appear that he would step out.
Okay, and why, okay, let me try to rephrase this. What was your reasoning for making contact with him?
Because he was the offender, based off what the victim stated.
Okay, and did you tell him why you were placing him in handcuffs?
Yes.
Okay, and were you able to place him in handcuffs?
Yes, ma'am.
Okay, and what, if anything, happened next?
I began to escort him to the scout car.
Okay, and were you able to escort him to the scout car?
Yes, but with trouble.
And what do you mean by with trouble?
He began to resist and use dead weight.
Okay, and when you say use dead weight, what do you mean?
Like he laid flat on the ground.
Okay, and when he did that, did you say anything to him?
I asked him if he can get up.
And did he get up?
No, no.
What, if anything, happened next?
2 other assistant officers approached and we began to do a 4-man carry.
Okay, and do you recall those other officers' names?
Was Officer Courtney and Officer Flores.
Okay, and were you guys able to lift him up?
Yes, ma'am.
And what, if anything, happened next?
We got him to the scout car and began to search him.
Okay, and were you able to get him into the scout car?
Yes, with trouble.
Okay, and is that the same trouble that you already described to the court?
There was more trouble.
Okay, And could you explain to the court what you mean by there was more trouble?
While attempting to get him inside of the scout car, he resisted more. And while me and my Sergeant Vogel was attempting to place his legs inside the scout car, he began to kick his feet.
Okay, and when he began to kick his feet, were you injured?
No, ma'am.
Okay, well, did you see anyone get injured?
Yes, ma'am.
Who?
My sergeant.
And did you observe?
Objection, that's hearsay, we gotta know.
What's the statement that you're objecting to?
That a sergeant was injured, I believe?
I didn't hear a statement. He said he observed his sergeant get injured. How is that hearsay? An out of court statement offered for the truth of the matter asserted.
Open trial.
May proceed.
Okay, and you, observed her get injured how?
She was kicked twice, I believe.
Okay, and do you know where she was kicked?
Is it fine if I check my report?
Will reviewing your report refresh your recollection?
Yes, ma'am.
Go ahead.
May I approach her?
Yes.
Please review your report and where your recollection is refreshed as to, where she, Sergeant Vogel was kicked. Please let the court know. Is your recollection refreshed?
Yes, ma'am.
Okay, where was Sergeant Vogel kicked?
I don't believe I had placed it in the report.
Okay, all right, and but after Sergeant Vogel was kicked, were you able to get him in the vehicle?
Yes, ma'am.
Okay, and as you stated he was kicking, did you give him any commands at the time he was kicked?
Yes, ma'am.
What were those commands?
Is it okay to use?
No.
Okay.
Did you give
Say
any
exactly
command?
what was said?
Okay, I stated that if he kicked my sergeant, I was going to fuck him up.
Okay, and did he stop kicking after you said that?
Yes, ma'am.
Okay. Nothing further from the people.
Cross exam.
You testified that you were called out because of domestic violence, reports? Yes?
Yes, sir.
Okay, and you saw someone leaving the house?
Yes, sir.
And you felt that this person was the victim?
He was questioned by other officers.
Why did you, okay. Did you talk to this person leaving the house?
Yes, when he approached the porch.
All right, I'm a little confused. When who approached the porch?
The man that walked out of the side of the house.
Oh, he walked out of the side of the house and came around to the front of the porch. Okay, and that's where you and your fellow officers talked to him?
Yes, sir.
And you knocked on the door or something? How did the door wind up getting open?
Mr. Willie Dale opened it.
Oh, and Mr. Willie Dale is a resident at this house?
I believe so.
Is it his house or you don't know?
Based off what the victim said, they both lived there.
Okay, and did you announce that you were the police to Mr. Dale before he opened the door?
No.
Okay. And you told Mr. Dale had a knife in his hand?
Yes, sir.
And he saw that you were police officers? I mean, you were in uniform, that means, right?
Yes.
And you told him to drop the knife?
Yes.
And he did?
Yes.
Okay. Then you placed Mr. Dale under arrest?
And handcuffs, yes, for further investigation.
Did you inform my client why he's being arrested?
He was placed.
No, I'm asking a question. Did you inform him why he's being arrested?
Said he was detained for further investigation.
But did you ever tell him why he was being arrested?
Yes,
When?
when he was placed in the scout car,
What did you tell him?
that he was placed under arrest for domestic violence.
So you told him after all of this, dead weight stuff and the kicking stuff, that he was being arrested for domestic violence.
Yes,
So, but prior to you telling him that, he had no idea why you were detaining him.
I do not know.
That's a fair answer, because he can't tell us what
Yeah.
someone else knows.
Okay.
Rephrase the question.
But the reason, I mean, okay. Never, he wasn't told why he was being taken to the squad car till after he was handcuffed and placed in the squad car. And after the kicking and after the dead weight, correct?
Yes.
Okay, I have no further questions.
No reason.
So officer, let me let's make sure I understand you correctly. You respond to this location on the domestic violence call. There's a person who comes out of the house, and based on what that person says, at that point, was it your intention to arrest the defendant?
It was my intention to detain him.
To detain him for further investigation?
Yes, sir.
All right, and you see the defendant emerge in the doorway with the knife. Is that right?
Yes, sir.
And you tell him to drop the knife, and you tell him to step outside.
Yes.
And he refuses to step outside.
Yes.
So you essentially bring him outside and arrest him, put him in handcuffs. Is that right?
Yes.
And in the midst of that, you're taking him to the squad car, and that's when he starts to resist.
Yes.
All right, any questions based on my question?
No?
Thank you, sir. You may step down.
People have no further witnesses, Your Honor.
Any witnesses for the, no? Right, people?
Your Honor, at this time, the people will request that the case be bound over. We do believe that it's a question of fact for the trier of fact. We did hear, testimony from Officer Tillman, who indicated he did go to the, to that residence for a police run in which he encountered, a person whom he identified as the victim, upon which he, which the defendant whom he identified here today in court emerged at the front door, in which he stated, the defendant opened with a knife. He told him to put the knife down. He indicated that, that he asked him to step out. He didn't, so he went to detain him. I asked why did he place him in handcuffs. He indicated that he was an offender based on information that he received from the person who identified as the victim without stating exactly what that information was. He indicated that on the way to the scout car, the defendant began to resist, and he explained that as being dead.
Just touch on the 5 points. I want
Okay.
to rehash the whole
Okay.
thing, because I heard it.
Okay, Your Honor. And basically, the defendant began to resist, and also in their resisting, had to do other officers came to assist, and upon which Officer Vogel was kicked. Your Honor. People believe this question.
Mr. Beaver?
The testifying officer and the prosecutors keep referring to a victim that no one's established that this person was a victim of anything. He's just a person walking out the door. My client is alleged to
Get into hearsay as to what the alleged victim said.
I don't want, I object to the establishment of this being that this person is a victim. No, that's never been established. But moving on, my client answered the door with a knife in his hand. It's his house. He has a legal right to answer the door with a knife in his hand. May not be a good idea, but there's nothing illegal about that. My client was seized and transported to a squad car without being informed why he was being arrested. He had no idea at this time whether this was a lawful arrest or not. It doesn't seem like a lawful arrest. My client had no idea why he's being arrested at this point. He's just being removed from the house that he owns and taken to a squad car. And after this dead weight and kicking incident, is then told why he's being arrested. He has a right to resist the unlawful arrest. And up until the point that he told us why being arrested, there's nothing lawful about why he's being arrested. Yeah, there's nothing illegal about answering the door with a knife. There's nothing been established that he's committed any crime yet, just a resisting and obstructing. I mean, it's kind of a, how to put it, a circular thing. He's getting all right. There should have to be some kind of foundational crime before you charge him with resisting and obstructing, because without it, what is the resisting and obstructing? I mean, he just did nothing but resist being unlawfully arrested. He was never told why he's being arrested until after he was placed in the back of a squad car. He's perfectly reasonable in not cooperating till then. If anything that happened after he was told why he was being arrested, that's a different matter. But there's no allegations that any of this stuff happened after he was been told he was being arrested.
Yeah, I don't know.
Okay, so Mr. Deeble, you're correct in that the defendant has a right to possess a knife, maybe even a gun within the curtilage of his own home. However, the police were called there for some kind of domestic violence call. And in going there and exercising their duties, they asked the defendant to step out of the home, and he refuses to do so. He had reason to know that they were police officers and they were performing their duties. Whether or not he was placed under arrest for a domestic violence or told that he was being placed under arrest for domestic violence, these are officers that are there performing their duties as officers. And the charges that he obstructed or opposed them in them exercising their duties as officers. As such, the court is satisfied that people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. Given that these were officers exercising their duties as police officers, and he obstructed and opposed or resisted them in them doing so. So the court will bind the defendant over to Wayne County 3rd Circuit Court Criminal Division for further proceedings. His arraignment on the information, date and time will be June 18th, 2024, at 9 o'clock a.m. Bond will be continued.
June 18th?
Yes, sir.
Thank you, Your Honor.
Thank you, sir.
Parties ready on Eric Owens? Calling case number 2357239, the people of the state of Michigan versus Eric Owens. The defendant is charged with count 1, controlled substance possession. This matter is scheduled for exam.
Appearances for the record, please.
Asia Lewis for the people, P85520.
And good morning, Your Honor, Alexander Schultz with the Neighborhood Defender Service, P85948, appearing on behalf of Mr. Owens, who is present in the courtroom. Mr. Owens, if you could state your name for the record.
Eric Owens. This is the date and time set for preliminary examination. Are the people ready to proceed?
The people are ready to proceed, Your Honor. We already voted.
How many witnesses for the people?
One.
Any preliminary matters?
Yes, Your Honor. So people move to admit the final drug analysis, that the suspected narcotics recovered tested positive for oxycodone.
Any objection?
We would have no objection for exam purposes only, Your Honor.
Admitted.
At this time, the people call Officer Kendall Hooper.
Please give your name and spelling to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Please have a seat in the witness box. You may begin when you're ready.
Can you please state your name and occupation for the record?
My name is Kendall Hooper. I'm a detective trooper with the Michigan State Police.
Okay. And were you working in that capacity on June 6, 2022?
Yes,
And on this particular day, were you working by yourself, a partner, or a team?
yeah, as a team.
Okay. And were you working in full or modified uniform?
More than likely at a modified uniform.
Okay. And were you on foot patrol or scout guard this day?
On this day, we're executing a search warrant.
Okay. And were you executing a search warrant at 8081 Woodlawn Street?
Yes,
And is that in the city of Detroit, County of Wayne?
yes.
Okay. And did you make entry into, well, is that a residence or an
It is
apartment?
a residence of the Border Patrol Tactical Team, which is known by the name Border Residence.
Okay, so you can't say that at the end. Just keep,
No, I'm sorry. I did not make entry to the residence. The Border Patrol Tactical Team did.
Okay.
I'm
And did
sorry, you said Porter?
Border Patrol.
Thank you.
Okay. And after they made entry, did you ever go into the house?
Yes,
Okay. And when you went into the home, what did you do?
I was advised by Detective Trooper Kaiser that he had observed.
1 second. You can't say what he said, but you received some information from who?
I received information from Detective Trooper Kaiser that he had,
Don't state what he observed. You received some information from Trooper Kaiser, correct?
yes,
And did you do anything as a result of receiving that information?
yes, I obtained a search warrant for the residence, a narcotic search warrant.
Okay. And when you after obtaining that narcotic search warrant, what did you do next?
We searched the residence,
Okay. And where did you search?
throughout the entire house.
Okay. And did you recover anything?
Yes,
From where did you recover?
the kitchen and the bedroom.
Okay. And how many bedrooms was in this house?
I believe there was 2, but there could have been 3, I don't remember.
Okay. And you recovered from the kitchen and the bedroom. What did you recover?
Multiple pills that were suspected of being oxycodone.
Okay. And did you place those recoveries on evidence?
Yes,
And do you recall a description of what it was that you recovered?
the pills,
Yes.
they were white, circular pills. They had stamp on them, which I don't remember this,
We're reviewing your report, refresh your recollection as to.
yes.
May I approach you?
Yes.
Please review your report and where your recollection is refreshed as to the description of the pills recovered. Please, let the court know. Is your recollection refreshed?
Yes,
Okay, could you please let the court know, what the description of the pills were?
they're white circular pills stamped with RP, and on the other side there was 10-3-2-5.
Okay, and from where did you recover those?
The bedroom and the kitchen area.
Okay, and could you indicate to the court a description of, were these pills just out loose?
One half of the pill was on a, kind of like a counter between the kitchen and the living room. And then other pills were located in two separate, pill bottles that appeared to, have Eric's name or Eric Owens' name.
Okay, now, when you executed this search warrant, was there anyone there?
Eric.
Okay, and the person who you're referring to as Eric, do you see him here in the courtroom
I
today?
do.
Would you please point to and identify article of clothing?
He has a green, t-shirt with underneath or over a white, long-sleeve t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant. And was there anyone else in this home at the time?
I don't remember.
Okay, we're reviewing your report, refresh your recollection as to whether anyone else was there.
Yes.
May I approach again, Your Honor? Was there anyone else in the home at the time?
The report reflects no. Nobody, I believe he was the only person at the time.
Okay, and you stated that, some of the pills were located inside of a pill bottle.
Yes.
And did that pill bottle, have a label on it of any sort?
Yes, they were defaced, but they appeared to, have his name on it.
Okay, and as a result of that recovery, did you do anything, regarding that pill bottle?
It was seized into evidence as well.
Okay, you placed that into evidence?
Yes.
Okay, and did you ascertain, were you able to ascertain what that label, on that pill bottle was for?
The pill bottle was for the prednisone, which obviously is not oxycodone. While on scene, I was able to seize the pills, utilize drugs.com, which is an open source.
And is drugs.com something you use as in the ordinary course of business as a police officer?
Yes.
Okay, and did you use drugs.com to identify the pills recovered on this day?
I did.
Okay, and what was the finding of that?
That they were oxycodone pills.
Okay, and were you the one who submitted these the pills that you placed on evidence to the for testing?
Yes, I submitted to the lab for further testing.
Okay. And was you able to ascertain anything else? Well, you know, 1 second, Your Honor. Nothing further from the people.
Cross examine.
Detective?
Yeah, detective's fine.
I'm gonna ask you a couple of questions, and if anyone always said sure or anything like that, let me know and I'll rephrase. So you stated that it was on June 6th of 2022 that this warrant was executed, is that correct?
The fugitive warrant was executed, and both warrants, a fugitive and the narcotics warrant.
Okay, and let me ask you, prior to this date, had any other warrant been executed on Mr. Owens?
Yes.
Okay, and was it the basis of that warrant that led to this warrant, is that correct?
Yes, that case led to the fugitive warrant.
Okay, so based on the information from the previous case, you then obtained was it just an arrest warrant or was it an arrest and a search warrant on this date?
Initially, it was a warrant for a fugitive.
Okay, and then was a search warrant ever also brought with that fugitive warrant?
I obtained on scene a narcotics warrant for the house.
Okay, and did you obtain it, you said prior to your own entry into the home?
Yes, before I walked into the house.
Okay, and what was the basis for that warrant then?
Items observed by, or information that I had been provided by Detective Trooper Peterson.
At this point, was Mr. Owens in the residence or had he been removed from the residence?
At what point are you talking about?
At the point where you entered the residence?
I first encountered him, I believe, in front of this front porch.
So he was no longer in the residence at the time?
I don't believe so.
Okay, so you enter the residence. And then you begin your narcotic search, is that correct?
Yes.
Okay, can you go through again where you located each of the pills that you stated?
There's a half of a pill in the, there's like a little divider with a flat top, kind of like almost like a counter between the kitchen area and the living room. One was found there, I believe, an additional bottle with a singular pill in it. The bottle was like also, I believe, prednisone. So the pill inside the bottle was not the correct prescription for it, or pill. The pill didn't match the bottle. And then there were, I believe, 8 located inside an additional prednisone bottle in the bedroom.
Okay. And where was the bottle located with only one pill?
I believe on the countertop, where the other half pill was between the kitchen and living room area.
So you observe these bottles, and then you observe what you believe to be the occupant on pills.
Yeah, we were able to get them out of the bottle and see that they had a stamp, and every pills have stamps or identifying marks on them, so they can identify.
The bottles that these pills were located in, they had Mr. Owens' name on the bottle, is that correct?
They appear to.
Okay, and did those appear to be prescription bottles as well?
Yes.
Okay. During the course of your investigation, did you ever conduct a search regarding Mr. Owens' past prescriptions?
I did. I conducted a MAPS report.
And what was the result of that report?
That I would have to look at it for exact dates, but at one point he was prescribed 7 of these pills, but we located 9.5 at his house.
Okay, so he'd been prescribed 7, you located 9.5.
Yes.
And then what service did you state you used to view his past prescriptions?
MAPS.
MAPS. I'm not as familiar with MAPS. Can I ask, what, is that a database that is universal with regards to prescription?
I'm not 100% sure what it all shows, but generally it shows controlled substances. Like that would be, they would be prescribed. It wouldn't say like if you went, it shows, I guess, an easier way to explain it is it's a database that's not readily available. You have to seek, almost apply for it, and they'll accept you, and then put in information and case numbers, and it shows their past prescription history within, I think, a 5-year span.
Within a 5-year span. And is this something that is up to doctors to input that information, or prescribing physicians to input the information into MAPS?
I believe, I'm not that, I don't know, I'm not sure.
Okay, so would it be possible for Mr. Owens to have received a prescription from a physician and it to have not been updated into MAPS?
It could be, but I don't believe so. I believe MAPS is mandatory reporting.
Okay, and is it something that is exclusively in the state of Michigan?
I'm not sure. I'm not 100% positive, but the report might have what the acronym states. I believe it's Michigan Automated or something.
Okay, so to your knowledge, it is a Michigan-based database.
That is true.
And then just one more question for you. With regards to when you executed the warrant, were other prescription bottles found in this residence that you observed, described to Mr. Owens?
I don't remember.
No further questions at this time.
Can you redirect?
No redirect them.
So we have the defendant who has a valid prescription. And do you know what the date of that prescription was for?
If I can, just refresh this recollection.
Sure.
You can let the judge know.
December of 2021. I think it was billed the 18th. It was written on the 18th, billed on the 22nd.
Okay. 2021.
I think they're 7, 8 months prior.
Okay, any questions based on my question?
Can I just ask one question in regards to the maps? Do you have the date, do you recall the date range in which you ran the prescription database?
I believe it's 5, but I'm not 100% sure.
You ran it for the 5-year
I
span?
believe so, yes.
Okay.
And no questions.
Thank you, sir. You may step down.
Thank you.
No further witnesses. Your Honor, the people will request that the
I was
case.
asking the defense that they have.
Oh, I'm sorry. I thought
No
you-
witnesses, Your Honor.
Okay.
The people will request that the case be found over. We do believe this is a question of fact. For the trier of fact, Trooper Hooper, upon being with the team, executed a warrant for an arrest warrant, received information from Trooper Kaiser, upon which he obtained a search warrant for narcotics. He entered the residence, he recovered, I believe he said 1.5 pills from the kitchen counter, and then a bottle containing pills from the bedroom with Mr. Owens' name on it, who had identified here in court. He indicated that he ran, he did place those on evidence and sent those to the lab, in which that test indicates that the pills analyzed tested positive for oxycodone. He indicated that he did run a MAPS database for prescriptions to Mr. Owens, and that he indicated that he only had one prescription that was prescribed in December. This search warrant was executed in June. However, that prescription was for a 7 pills, and they recovered 9, I believe he said 9.5 pills, Your Honor. And the people will also indicate that the prescription bottle that was recovered was for prednisone, Your Honor. So people just believe that's a question of fact for trial.
Your Honor, at this time, defense would object to the bind over without argument.
Yes, I feel some kind of way about this case, in that I don't know if it's a cultural thing or what, but I just recall back in 2013, I had a blood clot that traveled to my lung, and I was prescribed something along the lines of oxycodone, but I never took the stuff because it was too strong, and I was worried about getting addicted to it, so I left it alone, and it's probably somewhere in my cabinet at home right now. If something was to happen to me today, and a doctor prescribed that to me, and that was longer than 5 years ago, that was back in 2013. A doctor prescribed that stuff to me today, then we would have a like situation in that I would have on record that it was just prescribed not long ago, but I still have these pills lying around from 2013 that I don't touch, have no intention on touching, don't want to sell it, don't want to use it, don't want to do anything with it, and no, you can't have it, okay? But then even more so from a cultural standpoint, I know people who share medication all the time. If I throw my back out, I have a cousin down the street who give me some muscle relaxers because she has them on hand, because she uses them. I hope I'm not committing a crime here, but corpus delicti is applicable here. You don't have it, so you can't charge me with it, okay? But this kind of bothers me a little bit, because if he has a valid prescription for the stuff, because he has a little access of it, why are we charging him with a felony? If he has a condition, I don't know what his condition is, I don't know what his ailment is, but this one doesn't necessarily sit right with me. Because the prescription says that he's only supposed to have 7 pills and he has 9.5. It doesn't appear as though he's using it. In fact, he's cutting the pills in half because it's probably too strong for him too. But I guess from a pure practical standpoint, a factual standpoint, there has been evidence that he was in possession of this controlled substance. So you say the pill bottle wasn't for oxycodone?
No, it was for prednisone.
I don't know the difference between the two.
But for it would be prescribed as the name, prednisone is not a generic version.
I have no idea. I don't get involved in things. But the people have presented evidence that the defendant was in possession of these controlled substances. As such, I don't think the court has any other choice but to bind it over. But I'm binding it over with reluctance because I don't like this. Then it will be bound over to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on the information, date and time will be June 11th, 2024 at 9:00 a.m. Bond will be continued.
But may I approach?
Yeah.
Yeah, because I need a second to run to the restroom. I'll be right back. Is that okay, Judge?
Yeah. Quarter session is finished.
Is it just my family that shares medication?
Nope, mine does.
Yeah.
I have it, my husband uses mine all the time.
Prednisone is a steroid, make the soft tissue of your body stop swelling.
Obviously, he has some kind of injury. But he's getting painkillers and stuff like that.
Yeah. Yeah. Okay.
Yeah, we're just waiting.
Everybody wants to hold.
Yeah, I know. I don't know. Must be you.
They don't do that next door. Everything is a dismissal and a waiver.
Oh.
Must be our prosecutor.
Yeah, that's what I said. So it's cool on this one. It's cool. Can I have?
Peterson. Attorney Hamilton, you holding.
I don't know about that.
I'm back.
All right.
Like,
Oh, you ready, Asia?
What's that? Are you answering?
What's that?
Huh?
When I go like put it up.
Oh, did you send that down?
No, can I
Oh,
send
that's
that
him right
down?
there. Yeah, I got it. Are we ready on Terry Peterson?
Yeah.
Is this a whole?
Huh?
It's a whole.
Yeah. Sorry.
Okay.
I think it's the prosecutor.
It's me, yeah.
Yeah, I know. No,
Yeah.
no, he's not here by this one. Calling case number 2456298, the people of the state of Michigan versus Terry Peterson. The defendant is charged with count 1, breaking and entering a building with intent. Count 2, burglary tools, possession. Count 3, controlled substance, possession. This matter is scheduled for exam.
Good morning, Your Honor. Angel Lewis for the people, P85520.
And Vanessa Hamilton, P82107, on behalf of Mr. Terry Peterson, who stands to my right, just say your name for the record.
There's a date time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor, the people are ready to proceed. At this time, we call Officer Bryce Murphy.
Sir, please give your name and spelling to the court reporter. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat with this box next to you.
Can you please state your name and occupation for the record?
Police Officer Bryce Murphy.
And Officer Murphy, are you the officer in charge regarding an incident that may or may not have occurred at 8406 Linwood?
Yes, ma'am.
And is that Linwood address in the city of Detroit County of Wayne?
Yes, ma'am.
And what was the nature of your involvement?
B&E police room, breaking and entering police room.
Okay. And did you ever actually go to the location?
No, ma'am.
Okay. And what did you do as the officer in charge?
Review of body worn camera footage of the officers. Review of green light footage.
And when you reviewed this green light footage, would you recognize that footage if you saw it today?
Repeat, I'm sorry.
Would you recognize that green light footage if you saw it today?
Yes, ma'am.
And do you recall what was on that, what you reviewed on that green light footage?
Yes, ma'am.
Okay. Does your recollection need to be refreshed as to, your observations of that green light footage?
No, ma'am.
Okay. And did you observe something on March 17, 2024 on that green light footage?
Yes, ma'am.
Okay. What did you observe?
Best evidence.
I'm getting it ready.
I observed.
One second. Just one.
No.
Can't zoom in and share the screen?
Yeah, I can do that. I just trying to go fast as fast.
If it's faster that way, by all means, go ahead.
I mean, no,
Whichever
because
way
you're
is
on.
faster.
Commissioner Sheriff's Department.
Make her a co-host.
Should be in there. Huh?
You made a co-host.
I just shared the screen so she can share it.
Do you recognize the, that video up on the screen?
Yes, ma'am.
And from where do you recognize it?
8406 Linwood.
Okay. And is this a, accurate reflection, just this little still photo of the, video that you reviewed in, investigating this matter?
Yes, ma'am.
And does it appear to be any decision made based on what you see here?
No, ma'am.
Playing
the beginning of the video. And let me just pause it just to ask a quick question. Did you review this video in its entirety?
Yes, ma'am.
And Your Honor, I'll just play it.
Okay. Was this video entered into evidence?
I was gonna do it after, but yeah, may I publish? Sorry. I'll stop there really quick just to get it into evidence. The people do, the officer indicated that the video is a fair and accurate representation of the video that he reviewed on the date in question. He also indicated that it appeared to be no deletions or alterations made. Your Honor, at this time, the people would move to admit this into evidence.
I would object, Your Honor. I don't feel that proper foundation's been laid. We've definitely heard that he's reviewed the video that was provided to him. I guess we don't know where it came from. It's not clear from the video what location this is. All we have is the officer saying that he looked at a video. We don't even have anything as to determine what
We do
happened.
need some foundation.
Yes, officer, is this the video that, could you indicate to the court how you're aware that this is the video that you reviewed?
Location is in the 10th precinct where I work.
How did you get this video?
It is a Project Greenlight video available to every officer that works in the city of Detroit for review at any time.
So this is stored at some kind of centralized location?
Affirmative. Yes, Your Honor.
Okay. And why did you go or review this particular video?
This was the location where he was arrested at that was listed in the report. So when I seen the address of 8406 Linwood, I reviewed the camera.
So you could go right to that particular camera to view video?
Yes, Your Honor, anytime.
All right, so no one can hand deliver anything to you. You're set up because it's a green light video where you can go to the location where an alleged crime took place and review video?
Yes, Your Honor.
Okay.
And could you indicate to the court, what is that, that up there on the screen on the bar there?
8406 Linwood Street, storefront camera.
Okay, and is that followed by date?
03/17/2024.
Okay, and is that the date in question that you were investigating?
Yes, ma'am.
Okay.
Was
And Your
there
Honor,
some kind of break-in at that location?
Yes, Your Honor.
All right, and who made the complaint, do you know?
The crime intel unit who monitors these cameras.
I see. So the owner of this establishment didn't make a formal complaint?
He was advised, once we realized it was being, he was contacted, advised that the store was broken into.
Did he indicate whether or not he gave permission for anyone to enter that location?
He stated he did not.
All right. What time of day was this?
10:30, about in the morning.
10:30 in the morning. Was the establishment open or closed?
It was closed.
He didn't give permission for anyone to enter that location?
Correct, Your Honor.
All right.
Thank you, Your Honor. I did have the owner here today.
Oh.
Yeah, but thank you for that. And may I continue playing the video?
Moving for admission, Ms. Hamilton, you still have an objection?
I would still object to the foundation, Your Honor. This is something that it sounds like is being reviewed after, after a police action has occurred.
Okay.
And so for that matter, you know, and to say one thing, this is again, just a video that he observed. I suppose we can view it here. I'll withdraw my objection to it.
All right, and then you may proceed.
Thank you.
Just to indicate that for some 5 minutes.
What did you say?
It's 5 more minutes. And that's. Officer Officer Murphy, were you able to recognize anyone in the video that you reviewed?
Yes, ma'am.
Who were you able to recognize?
The man that was arrested.
And how were you able to recognize him?
Once he was arrested, I spoke to him at the BBC.
Okay. And prior to speaking to him at the DDC, did you read him his rights?
Yes, ma'am.
Okay. And how did you advise him of his rights?
It was a written statement of constitutional rights form.
Okay. And did he appear to understand, did he appear to understand his rights?
Yes, ma'am, he signed.
Was his speech coherent?
Yes, ma'am.
And you indicated that he signed?
Yes, ma'am.
He signed the advice of rights form?
Yes, ma'am.
Okay. And the people would tender the witness for voir dire as to receiving his rights.
Voir dire is the voluntariness, Ms. Hamilton.
About to provide client.
I'm sorry. Voluntariness of the statement that was given.
Yes, I could ask it. Did you make a statement here?
No. You want to voir dire the witness as to the voluntariness of your client's alleged statement?
No, you're right.
All right, the court makes the finding that the statement is normally and voluntarily given, you may proceed.
Okay, and did he make a statement to you?
Yes, ma'am.
And do you see the person who you indicated was the man that was arrested and the man that you spoke with at the DDC? Do you recognize him in the courtroom today?
Yes, ma'am.
Can you please point to an identified article of clothing he's wearing?
Sitting in the blue polo shirt.
Your Honor, may the record reflect that the witness has identified the defendant. And would you recognize the statement that you saw today?
Yes, ma'am.
Okay. Your Honor, may I approach?
May.
And is that the statement that you took from the defendant?
Yes, ma'am.
And are you, how are you able to recognize it?
It is signed with my name, my writing, his signature.
And does it fairly and accurately depict the document that you recorded of the defendant's statement on that day?
Yes, ma'am.
Does it appear to be any deletions or alterations made?
No, ma'am.
Okay. And the people would ask that the officer be able to read the statement in the question and answer format.
May proceed.
So when you read it, you go question and then read the question, then answer, read the answer.
Question, do you understand that I'm conducting criminal investigation? Answer, yes. Question, why did you break into 8406 Linwood? Answer, I was working for the bank to make sure that the building was secure and boarded up. I arrived, the wood was loose. I took the boards off and replaced them with Tapcons to secure it. Question, who sent you? Answer, 5 brothers or Fannie Mae sent me an email with the location. Question, why did you enter? Answer, check and secure the back door of the residence. Question, who was with you? Answer, John, I hired him a week before. He had the U-Haul, says he lives in Southfield. I picked him up from a side street near 8 Mile and Evergreen. Question, why did he run? Answer, I don't know. He probably has a warrant or something. Question, anything else to add? Answer, I don't know why he left, and I'm sorry for it, but I'm telling the truth. That was the other question.
People have no further questions for this witness?
Cross-examine.
So a few questions. What date did you say that you viewed the green light video?
I can't recall the exact date. It was that day or next.
Okay, so it might have been the next day. It might not have been the same day as the incident.
It was viewed the same as it was happening, just not by me.
Okay, but it's if when you yourself reviewed the video, it wasn't the same day as the incident?
I don't recall exactly.
And in terms of the statement, I think you mentioned it, but you're the person that actually wrote down the questions and answers on the statement, is that correct?
Yes, sir.
No further questions.
Did you,
No, go ahead.
did you follow up on the defendant's story about being employed to go there and secure the location, that type of thing?
Yes, Your Honor.
And what were the results of the investigation?
I spoke with the owner, who's outside, who stated he did not give any authorization for anybody to go to the location, boarded up. He had the location boarded when it was closed.
All right, did the owner of that location indicate anything was stolen from that location on that day?
I don't believe so, Your Honor.
Nothing was taken from it?
No.
Any questions based on my question?
No, Your Honor.
No, Your Honor.
Thank you, sir. You may stay.
Thank you, Your Honor.
Any other witnesses for the people?
Your Honor, I did have the owner here, but I believe all the questions were answered in regards to that, what the owner could provide, Your Honor. So no further witnesses from the people.
Any witnesses for the defendant?
Nothing for the defense, Your Honor.
People?
And the people would bind over for, would motion for a bind over. We do understand that people have not presented any evidence as to count 3. So with that, the people will not move for bind over on that. As to count 1, the people understand that that nothing was taken from the location. However, the people still would move for bind over as to the breaking and entry, and if this court would still bind over on breaking and entering without intent, due to the fact that we do not have anything that was actually taken. But however, the people do believe that as to the intent to commit the crime of larceny would be a question of fact as to why he went in there. The people do indicate, will acknowledge that the defendant did make a statement indicating his reasoning for being there. However, there is testimony from the officer who spoke to the owner of the location, indicating that he did not give anyone permission to be there and that he himself had it boarded up. As to possession of the burglary tools, we see that this is, the video does speak for itself. This was a person who handled the crowbar, and I believe I saw 2 drills being handled by this defendant, which is the same person that was arrested coming out of the location on that video, Your Honor. So the people will move for bind over as counts 1 and 2.
So as it relates to count 1, you moving to do what?
I would like to bind over. I do believe that it's a question of fact as to the intent to commit larceny therein. However, if the court doesn't see that, I would like to move for bind over breaking an entry without intent. And I can try to get that MCL if the court is inclined to bind over on that.
All right.
No, Your Honor, we would object to bind over on both of the remaining counts. It sounds like they're moving to bind over on, first and foremost, count 1. I would say that what we have is only testimony suggesting his intent was to follow through on orders that he had received from another company asking him to secure this building. What we do have testimony that the owner was talked to, and that the owner said he didn't give anyone any sort of permission to do so. My client is still, it gave a statement stating that he was responding to some sort of bank, or it sounds like the owner of the ATM and their instruction. If anything, that suggests that perhaps there was some miscommunication, but what we don't have testimony of or any evidence of is that there was any sort of felony or other crime being committed inside of that building. Additionally, Your Honor, we don't have any testimony concerning what sort of tools were being used. We do have the video. It's unclear what tools were being used. There's no testimony suggesting that any tools were even confiscated in this manner. And again, Your Honor,
I have eyes. I saw him pry the door open myself.
Yes, Your Honor, but tools that are being used for the purpose of undergoing a work order or following through with one's employment are very different than tools that are being used for the purpose of.
Well, my understanding is the so-called work order was to secure, not open. Didn't look like he was securing anything.
He stated that he was removing, in his statement, he stated that he was removing loose boards and replacing them with Tapcon screws. Your Honor, and so I can't speak to his method of enacting his work orders, Your Honor.
Or did we see him go inside the location, stay in there for a period of time?
He also
until the police got there. I didn't see him trying to secure anything, did you?
He also made the statement that he was there to secure the back door of the area, so I'm not sure if this is the front or the back door, we don't know. But perhaps he was going in to continue to secure both ends of the building. I don't know what that building is.
Perhaps you're right, perhaps you're wrong. That's what makes it a question of fact to be determined by a trial.
But I think that in terms of every single element of the crime, Your Honor, we have not heard testimony on those things.
On the B&E without intent we have. I think we have that. We don't necessarily have, although it's not clear to me what was going on with those other folks that appeared to be taking or going back and forth to the U-Haul truck from the location. I thought that perhaps something was being removed, but the witness indicates that the owner of the establishment said that nothing was taken, so I'll leave it at that. But there was definitely a B&E without intent. As far as the burglar's tools, like I said, I have eyes just like you do. I saw him using what appeared to be tools to open up this establishment and remained in there for some period of time before when the police came in. I also take note that when the police came, if you're there for a legitimate reason, why are you running? Why did they run?
My client did not run, Your Honor.
Your client didn't have a chance to. Your client was still in the location. So the court is satisfied that people met their burden of probable cause as it relates to the amended charge of breaking and entering without intent to count 1, as well as count 2 burglar's tools possession. The court will dismiss count 3 for insufficient evidence. The court finding those charges were committed in the city of Detroit, and the court finding probable cause to believe this defendant committed them will bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 18th, 2024 at 9:00 a.m. Bond will be continued.
And the MCL for that is 750.111, and that'll be breaking and entering, illegal entry without owner's permission.
Thank you very much.
Thank you.
Ms. Johnson's coming up.
Are you ready? Latarian Johnson. Calling case number 2457004, the people of the state of Michigan versus Latarian Johnson. The defendant is charged with count 1, embezzlement, agent or trustee, $1,000 or more, but less than $20,000. Count 2, larceny in a building. This matter is scheduled for exam.
Good afternoon, Your Honor. Asia Lewis for the people, P85520.
Good afternoon, Your Honor. Paulina Montes, P number P87105, representing Ms. Latarian Johnson, who is present to my right. Ms. Johnson, could you please state your name for the record? Latarian Johnson.
Your Honor, the people are ready to proceed. It's my understanding that defense counsel and their client has elected to waive the preliminary examination, in which the people have no objection to.
That's correct, Your Honor. I've explained to Ms. Johnson the purpose of a preliminary examination. She waives her right to a preliminary examination today.
Ms. Johnson, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with the complaint. You understand that?
Yes.
You understand the nature and the purpose of a preliminary examination?
Yes.
You put your hand down. You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, that there's probable cause to believe you committed it?
Yes.
Are you sure?
Yes. It's kind of hard to hear you, but I did.
Oh, okay, let me talk a little louder.
Yeah.
Is anyone forcing you to waive your right?
No.
Has anyone promised you anything?
No.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No objection, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. Her arraignment on the information date and time will be June 18, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor.
Mr. Kenny, how you doing?
I'm good, Judge. How are you?
All right.
Good, good.
I'm playing musical chairs here.
Yeah. Just not bother me. Yes.
Oh, okay.
Yeah.
Calling case number 2359475, the people of the state of Michigan versus Maceo Smith. The defendant is charged with count 1, controlled substance, delivery, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Habitual offender, third notice. This matter is scheduled for exam.
Good afternoon, Your Honor. Agent Lewis for the people, P85520.
Good morning, Judge. Robert Kenny, appearing on behalf of Mr. Smith, who stands to my right.
Tell us your name, sir.
Maceo Smith.
There's date, time set for preliminary examination. Are the people ready to proceed?
Yes, Your Honor, the people are ready to proceed.
How many witnesses for you?
I believe defense counsel has a motion, but,
Yeah, I was going to ask for an adjournment.
Why?
Well, because I just met Mr. Smith. I haven't had an opportunity to, well, we had an opportunity to go over the paper discovery just now. But at the probable cause conference, they didn't let Mr. Smith know about that particular date. They highlighted today's date. They gave me the wrong address, telephone number that I had was not giving me access to Mr. Smith. And but I have talked to him about his case. I just haven't been able to go over the videos. So if you're not inclined to give us an adjournment, I think that Mr. Smith understands what a preliminary examination is and agrees with me that it's in his best interest to waive that exam. And
Do you have civilian witnesses or police officers?
police officers.
How long is the video?
there's 3 of them, and it takes an hour, at least an hour apiece to download them. I haven't downloaded them yet.
I really don't want to adjourn.
Well, Mr. Smith understands that he has a right to a preliminary examination. He actually was asking me about waiving this exam when he walked in. So I think he understands everything. He understands that he will be bound over on the charges contained in the complaint and warrant to Third Circuit. Is that correct?
Yes, Your Honor.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand, as your counsel just indicated, you understand you have the statutory right to have a preliminary examination. By waiving the same, that means you won't have one. Put your hand up. That means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with the complaint. You understand that?
Yes, sir.
You understand the nature and the purpose of a preliminary examination?
Yes, Your Honor.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, that there's probable cause to believe you committed it?
Yes, Your Honor.
Is anyone forcing you to waive your right?
No, Your Honor.
Has anyone promised you?
No, Your Honor.
Are you waiving your right freely, voluntarily?
Yes, Your Honor.
Any objection from the people? Any objection?
No objections, Your Honor, I'm sorry.
The court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on the information date and time will be June 18, 2024 at 9:00 a.m. Bond will be continued.
Thank you, Judge.
Thank you. They didn't sign it.
Oh, okay, that's. Must have been an extra. I took it out for him to sign.
Oh.
That's not, oh. It's to the federals. That's what you do.
How you doing?
I'm well, not easy.
Okay.
Mr. Kim. Mr. Kim. All right, we ready on Taiwan Jackson? You're ready. Calling case number 2457276, the people of the state of Michigan versus Taiwan Jackson. The defendant is charged with count 1, weapons, firearms, possession by prohibited person, count 2, weapons, ammunition, possession by prohibited person, count 3, weapons, dangerous weapon, carrying with unlawful intent, count 4, assault with a dangerous weapon, felonious assault, count 5, count 6, count 7, count 8, weapon, felony, firearm, habitual offender, second notice. This matter is scheduled for exam.
Agent Lewis for the people, P85520. Hey, good afternoon, Judge. May I please report Becky Nance, P68686, appearing on behalf of Mr. Jackson. Mr. Jackson, would you please state your name for the record?
Taiwan Jackson. Okay, and Ms. Nance?
So today is the date and time set for preliminary examination. Madam Prosecutor and I, we've had a conversation. I think there's a motion that she would like to make before we move forward.
Yes, Your Honor, the people move to dismiss count 4 and count 8 to the complaining witness, Stanley Jordan, failing to appear. And are ready to proceed on the other charges in which the defense counsel has notified me that they have elected to waive based on those circumstances.
That is correct, Judge. We have no objection to the motion to dismiss count 4 and count 8 as relates to Mr. Jackson and his statutory right to a preliminary examination. We have reviewed the discovery. We've gone over his right to have a preliminary examination and what must be shown. It is my understanding that Mr. Jackson would like to waive his right to a preliminary examination on the remaining charges and be found over circuit court. Is that correct, Mr. Jackson?
Yes, ma'am. Okay, Mr. Jackson, raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You put your hand up. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one and you'll be bound over on the complaint and warrant except for counts 4 and 8. Is that your understanding?
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution would have to establish the crime and charge of the city of Detroit with probable cause to believe you committed it.
Yes, sir.
Is anyone forcing you to waive your right?
No, sir.
Has anyone promised you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No objection, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings on counts 1, 2, 3, 5, 6, and 7. Mr. Raymond, on the information, date and time will be June 18th, 2024, at 9:00 a.m. Bond will be continued.
Let me address a couple of things regarding Mr. Jackson's bond.
Okay.
Mr. Jackson has just advised me that his stepmother has passed away. Her funeral is scheduled for June 8th at 11 a.m. The location is going to be at the C.W. Morris Funeral Home. He is asking the court for permission to be able to attend her funeral. There is a house arrest associated with his bond, but he has been given the ability to go to work, which is from 9 to 6, Monday through Friday. So he's asking the court to allow him to attend his stepmother's funeral. If the court would allow him to attend the wake, I believe is the day before.
Yes.
The day before on as well, to be with the family, he would be appreciative of that. No objections from people, yeah.
Give me an order to that effect, I'll sign.
I certainly will. And then one additional thing, Judge, he's also requesting from the court the ability to go to the hospital. He was previously shot, so there is some wounds that he would like to see. He's advised me that his doctor, his name is Dr. McCunley. He is at the health center in Highland Park on Woodward. He would like to be able to go to his doctor's appointments if he provides that information in advance to the Tether Department.
I have no issues with that.
Thank you.
Include that in the order as well.
Thank you very much, Judge.
All right, thank you.
Yes, ma'am. I'll do it, yes.
Then there was one.
One.
Got one left, right?
That way.
It's
Syrian, Johnny. Yeah, she waved. That was Miss Montez.
Oh, okay. So we're finished.
Yeah.
She did it. I'll just have mine.
Right. She didn't even get no lunch. You wanna go get lunch?
Yeah, so we're hitting the national next week. We're going for Tuesday, we're leaving finance for Orlando.
I didn't think anybody was gonna wait.
They all held, didn't they? Every last one of them.
Right.
The one with the video, I was like, I will. The two officers didn't show, because it would have been, you know.
I need that code, Asia.
And he didn't give me the right timestamps to start it at a reasonable time.
I need code.
750, 1.15, 115 -A.
Dash A as an apple.
Yeah. He's gonna be able to notice him though, from the tattoo above his eye. And I could.
Well, folks, that concludes Judge Giles' docket for today. He hopes to see you tomorrow. Well, I hope to see you tomorrow, same bat station, same bat time.
Oh, yeah.